Hello, my name is Jane Fong. I'm a real estate investor with over a decade of investing experience who left the full-time job in the IT industry for 22 years and started a real estate brokerage with a few partners. I like investing so much, I wanted to spend full time into real estate investing. Today, our topic is, can a landlord be exposed to construction lien? A disclaimer, I'm not a lawyer. I was just reading different court cases or different articles online. And if you want to have legal assistance, please consult with your legal counsel. What is a construction lien? A construction lien is if you hire a contractor to work on your property, they didn't get paid, the contractor could register a construction lien against your property, just like how a bank registers a mortgage against your property title. A construction lien is like, they are saying that you owe them money. Okay, that's why they register a lien on your title. And if they are not paid for the work, then the lien claimant, who is the contractor, can seek for the court's approval to sell the property to collect their money. This is what a construction lien means, and it is there to protect the contractor because, if they didn't get paid, they have a way to claim the money back. So let's go through some of the scenarios. This scenario is provided by the buildersontario.com, and let's read what the scenario is. The excerpt. The foundation contractor subs out the excavation of the foundation. The excavation contractor hires a couple of the laborers who do some hand shoveling and the other work. After the first day, the workers get fired for loafing on the job, and the contractor did not pay them. It is not a problem for either the foundation or the excavation contractors. The problem is the homeowners because the laborers can place a lien for payments against the property. The same holds true for a plumber that didn't pay for the material supplied during a rough-in. The supplier can place a lien against your property for money owed by the plumber. So what did we just read? So what they're saying is, for example, if you hire a contractor and that contractor hires a subcontractor, which is very common, you pay the contractor, but the contractor didn't pay the subcontractor, the subcontractor can register a construction lien against your property's title. Okay, the subcontractor will say that you are owing them money. Okay, of course, the lien has to be proven in court, but then once they register lien, they will have to, within a certain days, which is 60 days by now, I believe, to create an action to sue you and stuff like that. Then it becomes very hairy for us as a landlord. And another example that they're given is, let's pretend you hire a contractor, the contractor hire a subcontractor, the subcontractor purchase some supply from a manufacturers, and the subcontractor didn't pay the manufacturer. So now the manufacturer put a lien against your property to say that you owe them money. So this is the example that the passage has provided. Let's look at another scenario. The next scenario is about tenants. This excerpt is from this website. If payments for tenant improvements are accounted for under the lease or any other agreement between tenants and landlord, the landlord's freehold interest in the property is subject to a lien in the amount of 10% of the value of the payment or funding as per the lease. It appears that payments will likely incur any tenant inducement. In response to this, a landlord may believe they can escape lien exposure by eliminating any tenant improvements allowance contained in the lease. While this will help manage their exposure, the Act has also included a new section confirming that landlords may be treated as traditional owners if they meet the definition of owners as defined in the Act. Specifically, if an improvement to the premises is done at the request of the landlord or with the consent of the landlord and to the benefit of the landlord will be considered an owner and therefore face lien exposure for the full amount of the improvement. Okay, again, what did we just read? Okay, so for example, For example, let's pretend that, one of the tenants wants to paint the house. The landlord agrees. The landlord provide consent, said, yeah, you can paint the house. The landlord even supply money for the paint, and they agree that the landlord will supply money for this job, which will kind of cover the paint, and the tenant will covers the rest of the payment. So let's pretend if the tenants go hire a contractor to paint, but the tenants didn't pay the contractor. The contractor might have a potential lien against the owner, which is the landlord, and the landlord in this case may be exposed for a construction lien. Okay, so of course, all of this needs to be proven in court. However, the fact that they might have the possibility of putting a construction lien on your property is already very troublesome. And if they continue to perfect it and preserve it or perfect it, then you are going to get into a lawsuit situation. Having a construction lien on a title, if you don't need to talk to the bank or get a remortgage or get a refinance, it might not affect you that much immediately. However, if you need to sell your properties or if you need to get a mortgage from the bank, that might be a little troublesome. So at the end of the day, what should we do as landlord? Well, the first thing we need to do is we must be sure we hire a good contractor. Don't hire the contractor who will be not paying the subcontractor and causing the subcontractor to be doing something crazy like, registering a lien against your property. And when you have an agreement with the contractor, make sure that, the agreement covers, the payments and the non-payment portion regarding subcontractors and whatever the subcontractors hire and whoever is, hiring the other subcontractor and the payment to the supplier, etc. Monitor the contractor closely to make sure that, they did the work, they get paid, etc. And also, personally, I will not consent for tenants improvement. Okay. If there's something that you want to improve to the property, improve it yourself, hire a contractor yourself, hire a good contractor yourself. If you leave it up to the tenants, you don't know what's going on. Like, let's pretend that, the tenant said, oh, me and my wife can do this deck for you for cheap. You just have to pay us $3,000 and we will get it done. And then you as a landlord has a side agreement with the tenants to say, yeah, I will pay you $3,000. And it turns out that the tenants go buy a whole bunch of supplies or hire subcontractor without telling you, and they didn't pay them. So what are you going to do? These subcontractors might have a claim against the lien. They might have a claim against it. So at the end of the day, just to be safe than sorry, I probably will not consent for tenants improvement, period. Okay, hope this session is helpful again. I was just reading these from the website and interpreting it and, understanding what they're trying to tell us. If you need legal advice, please talk to your lawyer, and hopefully nothing like this would happen to any of you. If one thing that I've been providing is I have a real estate treasure map, which my team will review and select properties that have investment potential on a regular basis. If you're interested to see what kind of potential properties are out there, please sign up here on my website. If you like the video, please like and subscribe to YouTube. My name is Jane Feng. If I can help you with purchasing investment properties or commercial properties, please feel free to contact me. Thank you and have a nice day.